Do you agree that the benchmark you propose has never been recognized by this court as the benchmark that's appropriate in these kinds of cases?
I don't think so, Justice Kagan. First, I mean, going back to Jingles, I think the benchmark there, even for multi-member districts, was neutrally drawn single-member districts, not racially gerrymandered single-member districts. And then when you continue—
Of course, you're requiring that there be that kind of benchmark. The question is not whether it's permissible. You are requiring that there be a race-neutral benchmark. And I'm asking whether that requirement has ever been stated in our precedents.
I think that's what Bush v. Vera, what Abrams, and what LULAC were all pushing towards when they said you must account for traditional districting principles. I don't know why you would even account for them, except that if a plaintiff's failure to account for them in their map, if plaintiffs fail to account for them in their map, then their map can't really shed any light on whether there's a problem.
I ask because what strikes me about this case is that under our precedent, it's kind of a slam dunk. If you just take our existing precedent the way it is, and the three judges below all found this. The three judges below said, this is an easy case. It's not one of the hard ones. It's not one of the boundary line cases. It was clear that the plaintiff satisfied the Jingles preconditions. And past that, you know, you're looking at a state where there are 27% of the population is African American, but only one of 7 districts, where there is incredible racially polarized voting, where there is a long history of racial discrimination in the state. Put all that together, and it seems clear that under our existing precedents, the inquiry is complete in just the way that the court below found. And, you know, it seems to me that you're coming here, and it's totally your right to do it, but really saying, change the way we look at Section 2 and its application.
Absolutely not, Your Honor. And respectfully, I thought this is such an edge case. This is a case where the plaintiffs have come forward with an expert who said it's hard to draw a second majority minority district by accident. It's a case where the named plaintiff, Evan Milligan himself, showed that it's hard to do it on purpose. He runs an Alabama-focused redistricting nonprofit. He had a team of trained map drawers try to draw a second majority black district in Alabama, and they couldn't do it. That's at page 511 of the joint appendix.